A very good afternoon, one and all present over here. Respected Dr. V. Gopi Ranganathan sir, respected Dr. C.M. Rao sir, Principal of MP Law College, Marathwada Legal and General Education Societies, Manikchand Pahade Law College, organized 1 week online lecture series on Code of Criminal Procedure, Juvenile Justice Care and Protection Act, and the Probation of Offenders Act. Dear attendees, today this is the fourth lecture of this 1 week lecture series. And the fourth lecture, in fourth lecture, we have Dr. V. Gopi Ranganathan sir, who will guide us on the topic of trial procedure before criminal code. Dr. V. Gopi Ranganathan sir is working as associate professor in the School of Law, Christ deemed to be University of Bangalore since 2015. Before joining, he was associated with Amity Law School, Delhi, ICFAI Law School, Hyderabad. He had 17 years of teaching experience. He also worked as legal officer, Sanghai Group Administrative Officer Office at Hyderabad. He had published 49 articles in both national and international journals, presented paper in 45 national and international conferences, graduated from Sri C.R. Reddy Law College, Eluru, Andhra Pradesh, awarded gold medal in Master of Laws with specialization in labor and industrial laws. Sir was awarded gold medal for PhD, the best thesis in year of 2014 from University, Visakhapatnam, Andhra Pradesh, on the food safety, including GM foods, international perspective, and the popular concern. Sir is guiding 2 PhD research scholars, and Sir was invited as resource person for various judicial aspirant institute and also various national and national law school across the country. Now I request to Sir, please guide us on the topic, the trial procedure before criminal courts. Before that, I request to all participants, if you have any query or questions, please kindly put into the chat box. After the lecture, Sir will answer all the questions. Over to you, Sir.
Respected, am I audible?
Yes, sir. Yes, sir.
Respected my Guru Manikyal Rao sir, CM Rao sir, and respected faculty colleagues, a warm good evening to all of you, my dear students too. So thank you for giving an opportunity. Can I share my screen, please?
Yes, sir. Yes, sir. Please.
Just one second. Sir, is it visible? Is it, are you able
yes,
to?
Yes, sir. Yes, sir. Yes, sir.
The image is fine.
Okay, sir. No problem.
Okay. Thank you for giving an opportunity to interact with you on the subject or on the concept of trial procedure before criminal courts. Even though if I see the title of or heading of your guest lecture, Criminal Procedure Code. Here I opted for trial procedure before criminal courts, even though I know criminal procedure code itself is it's an ocean. It's very difficult to handle all the concepts contained in the criminal procedure code. That's the reason just I'm going to share with you what will be the procedure before criminal courts and what happens. Why? Because whatever the provisions contained in the CRPC, coming to the practical aspects, it would not be applied by our legal fraternity also in certain aspects. So here I'm going to highlight about the trial procedure before criminal courts. As you already know, we have substantive law and procedural law. Always we have the apex court judgment also. Procedural laws should be always subservient to the substantive law. That means whatever the provisions contained in the procedural law, it should not force the litigants or advocates to apply. Sometimes the court has to apply its judicial mind, keeping in view of that it has to deliver the orders or judgments accordingly. Coming to the brief, if you go to the history of the criminal procedure code, as we already know, from 1600 onwards up to 1947, if you see from 1600 to up to 1858, almost all the territories in India were under the control of East India Company from 1600 to 1858. Slowly they came to India for a commercial purpose to turn to political purpose. In way of that, they required certain laws, rules, regulations, or legislations like that. We had the landmark in the year of 1833, that is, by passing of the Charter Act of 1833, we had the provisions for establishment of Law Commission. First Law Commission was established in British India during 1834 under the chairmanship of Lord Macaulay. He was the first Law Commission chairman. Second, we have 1853, 1861, like that, 1872, like that. So here, in those days, the Law Commission was instructed to prepare a draft on certain legislations or on certain laws. In way of that, the basic object of Law Commission is to consolidate and codification of laws, existing laws. In way of that, first Law Commission was instructed to prepare a draft on Lexi Loki report and relating to CPC and IPC and CRPC. So, if you observe clearly here, in those days, they took years and years to prepare a draft or bill, to draft a bill. It took nearly 15 to 20 years and it brought as an statute. So why I have been stressing on this point means nowadays also we have certain legislations, bills were drafted and it were enacted for nearly in 1 or 2 months and it was bill became an act also. But in those days they have taken a extreme measure or steps to bring the legislation like that. So here, if you see in those days we have presidency courts also and provincial courts also. In Madras, Bombay, and Calcutta, we have called as presidency towns. So we had the establishment of Supreme Courts under the Government of India Act 1858. We had a provision. Under the provisions under those acts, we had the establishment Regulating Act 1773 made a provision for the establishment of Supreme Court at Calcutta, Bombay, and Madras. We had the provincial courts also in the provinces, that is Bengal and Bihar and Orissa. We don't have the uniform legislative system in those days. There were different procedural laws. Keeping in view of that, the Criminal Procedure Supreme Court Act 1852, it was made applicable to the presidency towns only, that is Madras, Bombay, and Calcutta, and it was replaced by the High Court Criminal Procedure Act 1865. Why? Because before that we had the Indian High Courts Act 1861, which abolished the Supreme Courts, amalgamation of Crown Courts and Company Courts, and they brought the Indian High Courts Act 1861. You already know, after we had the second Law Commission 1853, which was instructed to prepare a draft on CRPC under the chairmanship of Lord Romale. So keeping in view of that, we had the Criminal Procedure Code 1861, which made applicable for provinces. Later, it was replaced by another code 1872 and Uniform Criminal Procedure brought in the year of 1882. That means we don't have separate for the presidency towns and provincial courts like that. They made a uniformity of approach and it was replaced by the another code, Criminal Procedure Code 1898. So this Criminal Procedure Code 1898 we followed up to 1973. If you observe this Code of Criminal Procedure 1973, it was brought keeping in view of Law Commission reports. We have 35, 37, 38. Whatever the Law Commission reports were given after free independent India, after India become independently free, after attaining independence, so that Law Commission also doing the same job, that is consolidation and codification of laws. Keeping in view of that, this Code of Criminal Procedure 1973, which brought into force from April 1st, 1974, it consisting of 484 sections and 2 schedules. If you observe, the first schedule plays a very, very important role for the Code of Criminal Procedure. So every advocate so should have the awareness pertaining to the first schedule. Generally, in the courts also, they will see classification of offences, whether this case come under the purview of cognizable or non-cognizable, bailable or non-bailable, which court can take the cognizance of that complaint, which court can try the matter. Like that, we had the information under the first schedule. Coming to the second schedule, it deals with the certain forms, warrant form, dispense with petition. Simply, we had the format, whatever we have to file before the criminal courts. Even though this criminal procedure code was passed in the year of 1973, it was amended in 2000. We had the major amendments carried out in the year of 2005, 2006, 2009, 2010, and 2018 by law amendments. The purpose of carrying out those amendments were to meet with the present day situation. They carried out the amendments. Coming to the next one, original jurisdiction. Without dealing with the original jurisdiction, I cannot switch over to the other provisions contained in the Act. So here, the original jurisdiction of a court is the power to hear a case for the first time. That means the matter can be initiated before the court for the first time. Simply, it deals with which court can take the cognizance of offense. If you see the civil courts and criminal courts, in civil courts, as per the provisions of Civil Procedure Code, here I have to stress about section 15 of Civil Procedure Code, which deals with every suit shall be instituted in the court of lowest grade competent to try it. Lowest grade competent to try it. That means the suit has to be filed before the court, before the lowest grade to competent to try it. Coming to the in civil cases, we had the Civil Procedure Code which deals with the procedural aspects, and but coming to the criminal courts, every matter should be and filed or instituted before the magistrate court only. If you observe in the next slide, we can understand about the this system. We had the hierarchy of courts. Just I prepared keeping in view of the Maharashtra. We had the Maharashtra Civil Courts Act 1869, which deals with the civil judge in brackets junior division. Coming to the judicial first class magistrate, we had the information under criminal procedure code, and civil judge senior division under Maharashtra Civil Courts Act 1869, assistant sessions judge, district judge or sessions judge. The basic object of showing this slide is here. Coming to the civil courts, Maharashtra Civil Courts Act 1869, which deals with the pecuniary jurisdiction. That means it depends upon the subject matter. If the subject matter or the value of the suit is up to 5 lakh rupees, it can be filed before the civil judge junior division. Above 5 lakhs, it can be brought before the senior division. And district judge had the appellate jurisdiction. Here, please remember one thing. If you go to the civil courts, we will have civil judge 1, civil judge 2. In other states, they are called as first junior civil judge, second junior civil judge, third junior civil judge, like that. Why we have the number of courts of the same rank means for their administrative convenience. That means if we had the same court means it will become overburdened. Coming to the judicial first class magistrate. So we here I didn't mention about the second class judicial magistrate. Nowadays, except in some places, we don't have the second class judicial magistrates. We had the judicial first class magistrate. Next we have, there also we will have judicial first class magistrate 1, 2, 3, 4, like that. It depends upon the police station limits also. For example, wherever we have certain area, Gandhi Nagar at Aurangabad. So Gandhinagar at Aurangabad will have one police station. That police station will have certain territorial limits. Whenever the offense occurred at the territorial police station limits means it can be brought before the one judicial magistrate court. So if you observe the advocate diary in first pages and second pages, we can find the information pertaining to the which court can take the cognizance of complaint like that. Assistant Sessions Judge. Here, judicial first class magistrate can take up the matters or offences for which the punishment up to 3 years, the fine up to 10,000 rupees. Coming to the assistant sessions judge, we had 7 years. Next sessions judge, more than 7 years, and relating to the death sentence, imprisonment for life. It can also impose the death sentence subject to the confirmation of High Court. Here, yesterday also just I am going through the e-court system at Maharashtra. We had the sessions judge, additional sessions judge of the same rank. We had the assistant sessions judge, and we had the uh, adjunct first class ad hoc first class judicial magistrates also. But under the provisions of criminal procedure code, we had the setup of metropolitan magistrate courts also. Metropolitan magistrate means in any city or town where the population exceeds 1 million, there the concerned state government has been empowered to establish the metropolitan magistrate. Simple. So wherever we are calling the first class judicial magistrate or judicial first class magistrate, in metropolitan cities we are calling them as metropolitan magistrates. That means whatever the matters can be entertained by or taken cognizance by judicial first class magistrate, it can be taken cognizance by the metropolitan magistrate. So I have been verifying also in Maharashtra we have certain cities or towns, metropolitan cities, but we don't have metropolitan magistrate courts. Even though after my lecture also, if I am wrong, you can correct me. If you come to Bangalore, it's a metropolitan city. We had the metropolitan magistrate courts. That means whenever we have the metropolitan court, if it is a metropolitan city, we don't have the mingling of jurisdiction of civil courts and criminal courts. We will have separate civil courts and separate criminal courts. Here I have shown you first class judicial magistrate, whenever he has been taking the cognizance of certain matters, in that context, he would be considered as judicial first class magistrate. Whenever he has been taking up any civil matter, suit for recovery of money, the same person can be considered as civil judge junior division. That means, so whenever we have the combination of both civil courts and criminal courts, but in metropolitan cities, we had the separate civil courts and separate criminal courts also. In that context, what is the purpose behind that means? So the matters can be adjudicated in an expedient manner. Keeping in view of that, in metropolitan cities, we have separate civil courts and criminal courts also. In this context, I already clarified about the original jurisdiction also. And if you come to the criminal procedure code, we had certain sections and two schedules. But every high court has been empowered to frame certain rules. Pertaining to the civil aspects, we can find civil rules of practice. Coming to the criminal aspects, we have criminal rules of practice and circular orders. But remember one thing, in certain states, unfortunately till now, we don't have the criminal rules of practice and circular orders. I will show in the next slide also. Supreme Court in 2017, it gave a directions to the all the high courts to come up with the criminal rules of practice and circular orders. These criminal rules of practice and circular orders are supplemental to the provisions or sections contained in the Criminal Procedure Code. For example, process fee. How the process fee can be paid, to whom the process fee has to be paid, what is the relevant procedure, everything we can find in the criminal procedure, criminal rules of practice and circular orders. At the same time, if any person is unable to speak or unable to hear, for that purpose, we had the provisions contained in the Indian Evidence Act 118, 119, but we had the supplemental information contained in the Criminal Rules of Practice and Circular Orders. So here, listen one thing, whatever we have the administration of criminal justice, it has been categorized on certain three parameters, that is investigation and inquiry and trial. As you already know, whenever any offense has occurred, so basing upon the report given by the person called as informant, he will approach the police station and he will inform the police. The concerned officer will record it and he will prepare the first information report. Later, he will conduct the investigation. We had the provisions contained in the CRPC also. Without information, if the investigating officer had a suspicion about an offense, subject to the permission of the magistrate, he can also conduct the investigation. In investigation, we have the police officer will conduct the investigation and he will reach to the spot and he will also take the statement of the witnesses, and under section 161 and 162 of CRPC, and he will prepare the panchanama and he will prepare the rough sketch of the spot. Everything would be recorded. Basing upon that, he will prepare the charge sheet and he will produce before the magistrate court. Inquiry means, so it would be conducted, it would be happened before the magistrate. If the, for example, if any person approaches directly magistrate relating to one offense, so the magistrate will ask the concerned person, why you are not filed the FIR? If the person informs the court that even though they are not taking up of my FIR, means the magistrate will conduct the inquiry whether it is correct or not, then he can he can instruct the investigating officer to conduct an investigation also. Next one is trial. We don't have any, we have the definition pertaining to the investigation, inquiry under the provisions of Criminal Procedure Code. Under the definition part itself, we have certain words. Unless and until the context otherwise requires, we have to construe or understand the terms accordingly, whatever contained in the definition part. But we don't have any exact definition pertaining to the trial. What is trial? Trial is nothing but it is an adjudication of dispute. It is a adjudication of dispute by judicial process. Basing upon that, the person, the person who has been alleged, he can be declared as an offense, he can be convicted or he can also be acquitted also. For that purpose, what is required is trial has to happen before the court. So in this context, it's very, very important, even though you know the information pertaining to the, we have certain basic terms under the Criminal Procedure Code. We have to understand those basic terms relating to the cognizable offense defined under section 2C. So nothing but police officer can arrest without warrant. Whatever we have certain heinous crimes, serious crimes, it can be brought under the purview of cognizable offenses. And next one is non-cognizable offense. Police officer has to arrest with warrant only. So even though whatever the content in the definition part have been simplifying here. Next one is pertaining to the inquiry. It's other than the trial conducted under this code by a magistrate or court. So in this context, whenever the any offense has taken place, either the police officer police officer has to file a report before the court. In according to the section 190 of Criminal Procedure Code, which court he has to approach. I already shown the hierarchy of courts to you. That is judicial magistrate of first class, assistant sessions judge and sessions judge. So in civil matters, it depends upon the pecuniary jurisdiction. That means without going to the junior civil judge court directly, if the property worth exceeds 10 lakhs means he can go to the senior civil judge. Here, pecuniary jurisdiction, it differs from state to state. In Maharashtra 5 lakhs, in Telangana state 15 lakhs, in other state 10 lakhs pertaining to the junior civil judge court. But relating to the criminal cases directly, so here the criminal, that is first class judicial magistrate court or metropolitan magistrate court can take the cognizance of complaint basing upon the police report, first thing. Second thing is other than the police report. Third one is complaint. So complaint means it is pertaining to the private complaint. We are going to see in the other slides, in the next slides, that is pertaining to the section 200 of CRPC. So are you able to see my slides?
Yes, sir. Yes, sir.
Thank
Go
you.
ahead.
Thank you. So here, basing the expression taking of cognizance of offense has not been defined in the code. Upon receiving a complaint, upon a police report, information received from any person other than the police officer. First one is upon a receiving a complaint, it is pertaining to the private complaints, police report. The investigating officer, after conducting the investigation, he will file a police report, that is charge sheet, and upon information received from any other person other than police officer. Sometimes what happens, if the magistrate observes that the person deliberately giving the wrong information or he has been lying means, in that occasion he himself can voluntarily take up the matter also. So section 90 is very, very important. It is relating to the cognizance of offenses by magistrate. So here, magistrate court can take the cognizance of offenses. Which sort of offenses means any sort of offense mentioned in the Indian Penal Code. Even though it is relating to the 302, that is murder, or relating to the any heinous crimes or serious crimes also. So magistrate court will take up the matter, and after taking up the matter, what the magistrate court will do is it will apply its judicial mind. What is this applying judicial mind means? The magistrate court will observe the nature and circumstances of the case, whether this matter can be taken up by the magistrate court or whether it is committed to the sessions court or not. Keeping in view of that, it observes the matter. So here, at the stage of taking the cognizance, the magistrate will rely upon the sufficient grounds existing or not. If the sufficient grounds are not existing means, in that context, the matter can be dismissed also as per the provisions of Criminal Procedure Code. At the same time, nowadays what it is happening means, whenever any complaint has been filed before the court, obviously the accused is been approaching the High Court by filing a petition under section 482 of CRPC to quash the subordinate court proceedings. If you observe the section 482 of CRPC, it itself starts with non-obstante clause. That means whatever the provisions contained in the CRPC, High Court has been empowered to pass any order to prevent the abuse of process of the court and to secure and to meet the ends of justice. But section 482 had certain limitations also. Section 482, it's nothing but quashing the subordinate court proceedings relating to the discharging. If any accused want to discharge from that matter means, he may make a petition before the court. Otherwise, he can also approach the High Court by using the section 482 of CRPC. In this context, so the magistrate court will see its domain. The police officer will conduct the investigation. It's the exclusive domain of the police officer. Magistrate court has to take up the matter. It's the exclusive domain of the magistrate. Whether the matter can be taken cognizance or not. Here I have mentioned the expression taking cognizance of offense has not been defined in the code. Taking the cognizance is nothing but basing upon the averments contained in the complaint. Whatever the accusations has been made against the accused, keeping in view of that, it will take the cognizance of complaint. So complaint relating to the private complaints, whatever the report has been filed by the police officer or investigating officer, it will ask, he will submit before the court pertaining to the offense, and at the same time the accused would be summoned also. So the accused would also be produced before the court along by the investigating officer. In that context, even though it is a heinous crime, it has to be exclusively trialable by the sessions court. In that context, the magistrate court will refer to refer the accused to remand also. So here, upon a police report, upon information received from any other person other than police officer. Here, the word cognizance in legal parlance, it's nothing but cognizance is taking judicial notice by the court of law possessing jurisdiction on a cause or matter presented before it. It will decide the whether it can initiate the proceedings or not. So here the matter can be taken up whether it has a jurisdiction or not. In our CRPC, we had the provisions also. It arises basing upon the cause of action and nature of the offense, place of the offense, whether the matter can be taken up or not, whether the matter can be entertained or not. Section 193, it's very, very important. Cognizance of offense by courts of sessions. So under section 209 of Criminal Procedure Code, the magistrate court will commit the matter or refer the matter to the sessions court. If it thinks fit that this matter can be exclusively triable by the sessions court. In that context, what the magistrate court has to do means it has to follow the provisions contained in section 207 and section 208. Section 207 and 208 deals with the giving of the documents to the accused or to his counsel, and the FIR copy, Panchanama copy, and everything has to be given to the accused. Keep after giving the part all the things under section 209 of CRPC, the magistrate court has to give the notice to the public prosecutor of sessions court also. Here, all the matters, whatever the offenses contained in Indian Penal Code, initially it should be brought before the magistrate. Then it would be committal will happen by exercising under section 209 of Criminal Procedure Code. But there are certain offenses under special act. I have shown one example also pertaining to the narcotic drugs offenses. It can be directly brought before the sessions court also. Sessions court can directly take up that matter also. Coming to the third case, M.A. Kuttappan versus Krishnan Nayanar. This matter decided in the year of 2004. Why I have to take why I have been referring this case is I have specifically mentioned about the special court. Why the court would be considered as a special court means the concerned state government has to give a notification. It would be brought under the purview of special court. Special court means nowadays there are certain special courts only dealing with particular matters, but sessions court would be recognized or identified as a special court also to take up certain matters relating to NDPS cases like that. In that context, directly without approaching the magistrate court, directly they can go to the special court, that is sessions court. The sessions court will take up the matter. Here we had in this MA Kottappan case, actually we had one legislation, that is Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989, in which we had section 3 subsection 1 clause X and section 14. What happened in this matter? The matter directly filed before the Sessions Court. When the matter brought before the Supreme Court by way of appeals, the Supreme Court has held that even though it would be considered as a special court, so here pertaining to these offenses pertaining to the schedule mentioned under section 3 and section 14, it should be brought before the magistrate court, then only it will be committed to the sessions court. In this matter, so Supreme Court has held that the trial has to be conducted in a manner provided under Criminal Procedure Code, and the case has to be committed to the special court by the competent magistrate. So here, special court cannot entertain complaint directly and issue the process. It has to take the magistrate court has to take up the matter, then it has to be committed to the sessions court only. So the second point and third point is I showed certain examples of NDPS cases pertaining to atrocities case. We had the recent case also pertaining where the Supreme Court reasserted whatever happened in the Kottappan case relating to the atrocities case. Here, section 193 specifically mentions about the role of sessions court, and we have to understand with the provisions of section 209, even though have been covered about section 209 also. A court of session can take the cognizance of any offense unless the case it is committed to it by a magistrate, subject to following the section 207 and 208 of Criminal Procedure Code. Now, it's a new concept, as you already know, zero FIR. So here we had the provisions under the Criminal Procedure Code pertaining to the FIR, etc. So registering of FIR, we had certain directions given in the Lalita Kumari case also. Registering of FIR is mandatory like that. But what is this zero FIR? What it has been happening means, generally there is a one person, he approaches the one police station pertaining to one offense. The police people, after taking the content or note of it, they will refuse or decline to register the FIR. Why? Because we don't have any territorial, police station does not have any territorial jurisdiction over your complaint. The informant will get disappointed also. Here in this occasion, just have to recollect about the nearly in the 3 or 4 months back, the same incident has been happened. That is, after month recent incident, whatever happened in Hyderabad, where a young lady was brutally raped, smothered, and burnt by 4 women. So when her sister approached the police people, Shamshabad police, to register the FIR, they mentioned that the place of incident was outside their jurisdiction. Immediately, so after this, due to the whatever the alert came from media, etc., so the concerned Cyberabad police commissioner has given an instruction and suspended to police officials also. But we had the specific information contained in whatever the rulings given by the apex court. In the state of Andhra Pradesh versus Punati Ramulu AR 1993 and Satvinder Kaur case, in these matters, the Supreme Court has given a certain guidelines. Even though the police station does not have the jurisdiction, it has to register FIR and it can denote within the number as zero FIR. After that, it can be transferred to the territorial limits of police station. The basic object of it is, so if the delay happens means, in that context, there will be a tampering of evidence, all the manipulation of evidence, everything will happen. Keeping in view of that, Supreme Court has given certain guidelines. In 2013, after the Nirbhaya incidents also, Ministry of Home Affairs given it circulated its advisory to all the Inspector Generals and DIGs in respect to state to follow certain guidelines pertaining to the zero FIR. Why I have been taking up zero FIR in this context means it is pertaining to the jurisdiction. The police officer, even though he doesn't have the jurisdiction in that context, he has to register the matter as zero FIR. It can be transferred to the other police station also. Now the question is relating to the magistrate court doesn't have jurisdiction. Whether it can be take up the matter or not means we had the provisions under 201 of CRPC that magistrate can transfer the matter to the competent court to try the matter whatever it is having under its jurisdiction. So in this zero FIR, whatever we have, respective guidelines has been given recently also relating to the, we had other incidents also. We had the one example pertaining to the Sushant case. His father has registered FIR in Bihar. The offense has occurred at Mumbai. So keeping in view of that, with to what extent the matter can be taken up means we have certain guidelines given by the Supreme Court also in that matter. It has given certain guidelines and asserted pertaining to the zero FIR concept. Now, under section 200 and 190, I specifically mentioned that magistrate court can take the cognizance of offense basing upon the police report and relating to the private complaint other than the police report also. Section 200 of CRPC, which deals with private complaint. Private complaint means there are certain non-cognizable offenses. Directly, they can file a complaint before the certain non-cognizable offense without going to the police station. They can file the complaints also. Private complaint pertaining to defamation, like that. When the private complaint has been filed, the magistrate has to see that whether this matter can be taken cognizance by this magistrate court or not. We already learned that it would be exclusively triable by the sessions court means in that context, it can be committed to the sessions court, subject to giving the notice to the public prosecutor. Here, now, generally what happens means in sessions court, we can find public prosecutor, additional public prosecutor, like that. But in civil cases, we can find assistant government pleader, their tenure is up to their retirement. Coming to the as public prosecutor and additional public prosecutor, their tenure is for 3 years. But relating to assistant public prosecutor, APPs, who have been working who have been attending before the magistrate court on representing on behalf of the police station, that is state. So they have to write one examination which was conducted by the Directorate of Public Prosecutions. Keeping in view of that, basing upon the promotions, they may reach to the level of public prosecutor. But here, committal giving the notice to the public prosecutor or additional public prosecutor means their tenure is 3 years. Generally, even though it is out of the contest, these public prosecutors or additional public prosecutors appointed by the state government. Generally, practically what happens means whenever the government changes, like Attorney General of India, these public prosecutors and additional public prosecutors will also change. So it depends upon the what is that affinity or cordial relations with certain government or political party, they may become public prosecutor or additional public prosecutor. But don't take it granted, keeping in view of the political intervention like that, basing upon their expertise, experience also, they would be taken into consideration. So here section 200 of CRPC, examining the complainant and witnesses on oath. It's very, but whether it is mandatory for all complaints, no. We had the Supreme Court just have been making a comparative approach here. Section 138 of negotiable instrument is a special enactment. In section 138 of enact also, we had a special courts were also constituted for dealing of check bounce cases across the country. So here section 200 of CRPC, when any person files a private complaint pertaining to section 138 relating to dishonor of check, read with section 142 of enact. In NI Act itself, we had one provision, section 145, which deals with evidence affidavit. The complainant can file an evidence affidavit on oath. It could be taken for the aspect of inquiry, trial, and other proceedings. Section 145 only would be applicable to the complainant only. We had the Supreme Court decisions also in Indian Bank Association and others versus Union of India and others AR 2014, SC 2528, and we had the Andhra Pradesh High Court and various High Court decisions also. The magistrate need not take any oath, directly he can issue the summons to the accused. Directly process after paying the process fee by the complainant, summons can be served to the accused. Here what I have been highlighting here is, sorry, there are certain offenses, there is no need to magistrate to take up the examination on oath. By filing the evidence affidavit, with directly he can serve the summons to the accused also. Here multiple complaints in same transaction. We had one Supreme Court case, even though it is related to the earlier slide, for Damodar S. Prabhu versus Syed Babulal case, in which the Supreme Court mentioned that there is a one offense for which different courts will have jurisdiction. So here the complainant want to harass the accused. He filed a different complaints before the different courts. Coming to the brief facts contained in this matter, Damodar S. Prabhu case, here before the subordinate court in 2010, whenever the check has been dishonored, there are 5 places to file a complaint. For example, I have been issuing the check at Bangalore. So the concerned metropolitan magistrate can take up the matter. And if you have having your bank at Mumbai, that is payee bank or collecting banker at Mumbai, that the respective court can also take the cognizance of the matter wherever the notice has been issued. And so like that, wherever the accused had a registered office and wherever the he has been residing or personally working for gain, 3 to 4 places will have the different jurisdictional courts can take up the complaint. In this matter, the Supreme Court held that, so whenever for example, in one transaction, if the person has issued a 5 checks for first installment, second installment, third installment, fourth installment. First installment check has been dishonored, you filed a complaint at Mumbai. Second installment, Pune. Third installment, that means it depends upon the bank also. So the Supreme Court specifically mentioned and it gave a guidelines by exercising the power under Article 142 of the Constitution of India also, that whenever there is a same transaction, different complaints cannot be instituted before different courts. For that purpose, the complainant has to give a one undertaking before the court where the other complaints have not been filed before the other courts. The basic object behind that was it should not lead to the grave harassment of the accused. Next one is not competent to take cognizance of the case. I already clarified to you. So if the court doesn't have the jurisdiction, means it can return when the complaint is in writing. The complaint can be returned and it can give an order that you can present before the competent jurisdictional court. If the complaint is not in writing, it can direct the complainant to approach the proper court also. So here till now we had a basic idea about the cognizance of offense, committal of the case, and investigation, inquiry, zero FIR, and evidence affidavit pertaining to the other law for the time being in force. So, limitation for taking cognizance of certain offenses. Limitation for taking cognizance of certain offenses means, I think section 368, which deals with the limitation for taking the cognizance of certain offenses. So here for everything we should have the limitation. Without limitation, the matter cannot be taken up. The basic object of imposing the limitation is, if we don't have the limitation means obviously what happens, it would lead to the manipulation of the things, and it would also leads to the tampering of the evidence. Keeping in view of all those aspects, we had these certain parameters pertaining to the limitational aspects. So just I mentioned about 368. No, it's not 368, it is 468. So the basic object of limitation is taking the cognizance of the matter. If the offense is punishable with fine only, offense means whatever the offenses contained under Indian Penal Code, the limitation is 6 months. And if the imprisonment for a term not exceeding 1 year, the court can take the cognizance of that complaint or that matter within 1 year. And 3 years, exceeding 1 year but not exceeding 3 years. Just here, I want to highlight one thing. There are certain heinous crimes. For that purpose, we don't have any limitation. Here, how the limitation can be taken into cognizance means the date of knowledge. For example, one person went to his native place. So he went to his native place. He returned after 1 month. He found that the theft was occurred at his home. So on the date on which he returned and when it came to his knowledge, it would be considered as a one of the parameter for limitation. From that date onwards, the limitation has to be calculated. We have a specific mention also to calculate the limitation, the day or the date on which the limitation is going to be calculated, the date has to be excluded. But whatever contained in the section 468, it also gave the power to the court. After limitation also the matter can be taken up if the party shows a reasonable and sufficient cause. So by filing a condone delay petition, the matter can also be taken up. So in that context, section 5 of the Limitation Act would be applicable to certain aspects also. Here, we had one Supreme Court case in reference to issue certain guidelines regarding certain inadequacies and deficiencies in criminal trials 2017 SCC online SC 298. So the basic object of this case is Justice S.A. Bobde and Justice L. Nageshwar Rao. uh, Actually, they are dealing with the other criminal petition. They observed certain inadequacies pertaining to that matter, whatever happened before the subordinate court. So keeping in view of that, the Supreme Court has given a certain guidelines, and it insisted all the high courts to frame with certain rules. Initially, I specifically mentioned that we don't have criminal rules of practice and circular orders in certain states. It is High Court has to frame certain these rules. It's the authority of the High Courts to frame the rules. After this decision, after this, every High Court has been instructed to follow certain rules pertaining to the criminal rules. If still they have not yet taken up means they have to follow the guidelines contained in this matter. Simple. If the investigating report after that, the police will submit that report, he will produce a list of witnesses also. So mentions the whoever he examined on the spot like that. After that, whenever the trial commences, generally magistrate court means the matter should be exclusively trialable by the magistrate court means if it is a so cognizable offense means in that context basing upon the charge sheet it will frame the charges, and after that prosecution has to give the submission to the court on what evidence he has been relying upon, and the court will also give the option to the defense also without producing any documents like that. So here the prosecution has to start their examination of witnesses. Their witnesses would be numbered as PW1, PW2, prosecution witness 1, prosecution witness 2, prosecution witness 3, and consecutively. But don't take it for granted. Whatever the report submitted by the police officer, those people will be taken up here. No, it's not like that. So whoever the witnesses produced before the magistrate court, that examination would happen. After the examination of witnesses, defense counsel will take the cross examination, and it would be typed on the same parameter, same para, and it would also read over to the concerned the complainant or concerned the witnesses. Basing upon that, his whatever the deposition given by the witnesses, it would be read over. Sometimes what happened, the language of the court will also be important. I also observed yesterday also relating to the decisions in the state of Maharashtra. In subordinate courts, they have been giving the decisions in vernacular language also. There are certain decisions which are in English language also. But the Supreme Court also asserted that if you are giving the decision in the vernacular language, when the matter comes to the High Court and Supreme Court, means again it has to be translated like that. So if you go to the Uttar Pradesh and Rajasthan, the decisions are given in Hindi before the subordinate courts. In this matter, the Supreme Court has given the certain guidelines, but uniform guidelines to be followed by the subordinate courts. That is numbering of witnesses, numbering of exhibits also, numbering of witnesses, numbering of exhibits, and relating to the, for example, exhibit on behalf of prosecution, P1, P2, P3 consecutively. If the exhibits produced by the defense, D1, D2, D3 consecutively. Sometimes we have court witnesses also, C1, capital C1, capital C2, capital C3, and consecutively. Sometimes we will have material objects also. It would be identified as MO1, MO2, MO3, MO4, etc. In this matter, the Supreme Court specifically mentioned that when the subordinate courts are, after taking up the trial, when it has been writing the judgment, it has to specifically mention the exhibit's name, how the parties has relied upon those exhibits, how the evidence has been produced before the court like that. Here, even though I have not been going to deal with the framing of charges in exclusive manner, so here the Supreme Court has specifically mentioned that when the court has been framing the charges, you should rely upon documents also. You should observe the record, and it should be heard by the parties. Keeping in view of that, so it has to frame the charges. Framing the charges means even though presumptions would also be applicable to certain extent, basing upon that the charges would be framed. Here, after the prosecution witnesses, examination of witnesses by the prosecution, next defense witnesses will commence. Before going to that, the court should give an opportunity to the accused under section 313 of CRPC. That is, so examination of the accused. The Supreme Court has specifically mentioned that it is a not only a statutory right but also a constitutional right enshrined in Article 21 of the Constitution of India. For example, the court has been also empowered to put certain questions also. Why? Because the basic object, whatever he want to say, for example, he says that I am not pleading guilty means trial will be conducted. If he pleads guilty in the initial stage or after the prosecution witnesses means, it is a discretion of the court to what extent the trial has to be conducted and how it has to be continued like that. Section 313 of CRPC, the court will give the, if you observe the, whatever the judgment given by the subordinate court also, we will have the examination of witnesses also. So for that purpose, the court will examine the witnesses and it will put certain questions also. So whatever the prosecution witnesses have you got any idea pertaining to the prosecution witness? Have you having the capacity to represented by the your counsel like that? So have you pleading the guilty or not, like that? Examination of accused would happen. Later the defense counsel defense examination will start. Sometimes what happens, so sometimes prosecution witnesses will also turn hostile. Immediately, re-examination will happen by seeking the permission of the court also. Prosecution first, prosecutor will examine his witness. Next, cross-examination. If during that cross-examination, if the prosecution found that he has turned hostile, means again he can request the court by seeking the permission from the court. Re-examination will also happen. I have been dealing with all these aspects. Sometimes what happens, witness turn hostile. When the witnesses are turning hostile means they should have certain protection. That is the reason it's a novel concept. That is the reason I added these slides also. We don't have any, even though we have section 195 capital A of CRPC, whenever there is a threat to the witness, subject to the provisions under IPC, action can be initiated. But we don't have any uniform guidelines pertaining to the witness protection. In Mahendra Chawla versus Union of India, the Supreme Court has given a Witness Protection Scheme 2018, which was drafted by the Police Bureau and Department. Keeping in view of that, they have been Witness Protection Scheme has been approved by the Apex Court. According to this Witness Protection Scheme 2018, every witness should have a protection. Why? Because whenever he has been deposing before the court, there should be a threat to his family members or to victim. Keeping in view of that, certain protection should happen. For that purpose, we have the witness relocation schemes, and they can also attend in virtual presentation also. Witness Protection Scheme 2018 has given certain parameters also. Certain expenses has to be incurred by the state also. Even though recently in 2020 also in the month of July, the Apex Court has held that even though we have given certain guidelines pertaining to the Witness Protection Scheme 2018, certain state governments have not been implementing that scheme. But in this context, I have to highlight one that Maharashtra is the first state. Maharashtra Witness Protection and Security Act 2017 we had the notified in January 2018. According to this act, earlier one is Witness Protection Scheme 2018 drafted by Bureau of Police like that, and Law Commission also given certain recommendations. Maharashtra, it's the first state which made certain parameters for the witness protection. We had the Witness Protection Committee, State Witness Protection Committee. If any person, victim or any person had the problem pertaining to the threat or any perception from the other parties, immediately he can approach the court or committees. Basing upon that, they will observe to what extent he can be protected. So they will give this some safe location. He has to stay there unless and until the completion of the trial. For that purpose, expenses would be incurred by the state. So it is the relating to the witness protection. The purpose of discussing of witness protection here is whenever the examination is happening before the court, we will have different kinds of witnesses also. Sometimes we will have chance witnesses, material witnesses, whatever they have been deposing before the court, whether it may be magistrate court or sessions court, it has to rely upon the nature of the offense also. We will have summons cases and we will have warrant cases like that. It has to adjudicate the matter keeping in view of the provisions of criminal procedure code. At the same time, we have summary trials also. Section 260 to 265, which deals with summary trials, for which we had the specific information What sort of matters can be adjudicated for a summary trial? The basic object of it is the matter has to be conducted in speedy manner. It has to be conducted in expedient manner. So we had the offenses for which punishment not exceeding 2 years, for which the state government will give a authority to certain courts to conduct the matters in summary manner also. So when the matter has been taken up by that court, the court can impose the punishment not exceeding 3 months. But the summary matter can also be, if the court finds that this matter cannot be adjudicated in a summary procedure, means it can also be converted into the regular procedure also. Here, the other thing is victim compensation. According to section 357 of Criminal Procedure Code, the court can award the compensation to the party also, keeping in view of nature and circumstances. In this context, I want to highlight one thing. For example, if you take check bounce cases nowadays, recently we had this statement also. So check bounce cases should not be penalized like that. You should not be considered as an offense like that. Actually, we had the amendments carried out in 2018 also. The basic object of the act would become futile also. Here, awarding the compensation means it depends upon the nature of offense also. What is the purpose of awarding the compensation to the victim or family means keeping in view of that their whatever their grievance or whatever it may be, it would be resorted to a limited extent also. We had this section 357 of CRPC. So here, filing of the charge sheet, framing of charges, and charges can also be altered. Next one is examination of parties and conclusion. After that, examination of the parties. Sometimes we will have the uh, expert witness also. Section 45 of the Indian Evidence Act, which deals with the expert witness also. But it would always have a persuasive only value only before the court. So keeping in view of that, it can also be taken up before the court. And next one is relating to the examination of witness. We had the provisions also under Indian Evidence Act from section 118 to 154, how the examination of witnesses can be happened like that. But we are dealing with the procedural aspect. Ultimately, it is the magistrate court or sessions court. Whenever they have been conducting all the trial, sometimes they will feel some sort of inconvenience also. Keeping in view of that, in the year of 1981, Justice Chennappa specifically mentioned that it would be a contest between the prosecution and defense, with the inevitable distortions flowing from the combative and competitive elements entering the trial procedure. So if a criminal court is to be an effective instrument in dispensing justice and recording all the things, means the court has to apply its judicial mind at the same time. So he should be participant in the trial. He has to observe all the things. He has to put certain questions also. We had these certain provisions in the Indian Evidence Act also. The court can also put certain questions also. At the same time, the court can observe the conduct or behavior of the person also. Keeping in view of that, everything would also be recorded by the court. So these are the, even though I know it's very, very difficult to have a glance on the trial system before the criminal courts, just it's only my endeavor or attempt to go through all the content. Anyway, thank you, please.
Thank you, sir, for a wonderful lecture. Sir, there is one question from our student.
Please.
That is, he asking that hostile is an offense, or is there any inquiry regarding this?
Okay. Under the provisions of CRPC, when the witness turns hostile, hostile means whenever there is an element of perjury like that, the provisions of IPC would be applicable. He himself voluntarily turning hostile means for that purpose, we don't have any punishment for that. We should have the element of perjury or deliberately has been lying, then the provisions of IPC would be applicable.
Thank you, sir. So, dear participant, there is a small announcement. Tomorrow we have Dr. C.M. Rao, sir, the principal of MP Law College. Sir will enlighten us on the topic of framing of charge on the same time, I request you all attendees kindly join on Zoom link, as well as the lecture will be live on YouTube. So on behalf of management, staff and student, I am very thankful to Dr. V.G. Ranganathan sir for his informative session on the topic of trial procedure before the criminal courts. I am very thankful to Dr. C.M. Rao sir, the principal of MP Law College, the teaching and non-teaching staff, and of course the all attendees who are patiently listening this particular lecture. With these few words, I conclude this today's lecture. We will meet on tomorrow. Thank you very much.
One
Sir,
second,
please.
sir.
Sir, please. Sir.
Thank you for giving an opportunity to interact with you, to all the faculty members,
Thank
and
you,
to
sir.
my guru CM Rao sir, all the faculty members. Thank you, sir. Thank you.
Thank you, sir.
I
Thank you,
also
sir.
learned about the Maharashtra witness protection due to this lecture only. I don't know pertaining to all the provisions.
Okay.
So you gave me an opportunity to learn about the Maharashtra witness protection scheme. Thank you very much, sir.
Thank you, sir.
Thank you,
Thank you, sir. Thank you, sir. Okay, sir.